Thank you, Tony. Good afternoon, ladies and gentlemen. So what I want to do is look at workers' rights and the June 2008 referendum. Say something about how we're moving towards a possible resolution of the problem in Lisbon too, and I hope our European colleagues will be able to tell us what's going on in relation to that, because we certainly don't have very much of a steer here. I then want to look at some key issues which arose in the Lisbon Treaty debate and seem to carry on, and just to give you a flavour of what is being done at EU level. Not saying a great deal about what's happening in Ireland, and I'm hoping that in the debate or the discussion we'll get some input from both or all the sides of the debate as to what's happening on the ground. I'll say what I can, but in not too much detail. As far as the June 2008 referendum was concerned, workers' rights did feature in the debate, and a lot of the parties, a lot of the groups did make some reference. And without endorsing it, I will say that Sinn Féin adopted a very hostile approach towards this treaty, explicitly based on problems with workers' rights at EU level. When we got to the Millward-Brown IMS survey, it's clear that workers' rights were seen as a very important issue. In fact, probably the single most important issue in that part of the survey, which they were looking at. But the sense of importance was actually quite evenly shared between the yes and the no camps. So as Millward-Brown looked at matters, workers' rights were not particularly divisive, but of course it depends which way you look at it and how you define your research. But clearly it was an important issue. Not surprising, for the past couple of years before that, we had seen an increased public focus on questions of race at the bottom, exploitation of third country but also accession state workers, and overriding immigration concerns as well. If you want to get a feel for how the worker side of the exercise saw things immediately after Lisbon, I would recommend you look at the situ paper on the Lisbon Treaty, What Next? Issues for Workers. There's arguments on both sides naturally, but it gave a slightly more nuanced idea of what the problems were, making it quite plain this was not just an EU problem which justified rejection next time around of the Lisbon Treaty, but it was also a national problem, problems that we in Ireland have in actually timely and effective implementation of community rules, but also the ability within Ireland's own sphere of competence to make sure that workers' rights are fully protected. And this was, I think, accepted, not necessarily in relation to trade union rights and so forth, but in relation to the issue of the race at the bottom, which I'll come to in a minute. I won't go into too much detail on this, and apologies for a rather heavy slide, but I'll just read it very quickly. Clearly, we are moving towards a second referendum, and the Oireachtas Subcommittee on Ireland did spend some time on looking at the issue of workers' rights, and a short section of the report crystallises very much where we are at in the debate. It did hear concerns that EU policies had a negative impact on the workers' rights, and it pointed to the neoliberal tendency in the Barroso Commission, and it pointed to the priority given by the Court of Justice to economic freedoms excuse me, over social rights. It saw the EU as a source of positive social legislation for Ireland, referring to the equal pay legislation and the Charter of Fundamental Rights. But there were clearly three areas on which it saw the need to give attention. First of all, clarification on the posting of workers, and I'm going to be coming to that in talking about the Court of Justice Adjustment in a minute. Secondly, on the desirability of a social progress protocol, at least in any future treaty. Not quite sure whether it should derail the Lisbon Treaty itself. And increased use of the Monti Clause, which in internal market legislation, including the Services Directive, has been used to make it plain that the internal market freedoms should not prejudice national rules on collective action, including the right to strike. And then the ORUCTA subcommittee also pointed to the importance of the continual development and consolidation of the social market economy. We then had for December 2008 European Council, with the Taoiseach expressing the concerns of the Irish people, including the need for the Union to confirm that the Union attaches high importance to the social protection of workers' rights. And the European Council has agreed to this and has agreed that high importance attached to the issues identified will be confirmed. We're not quite sure what's happening here. I certainly haven't been able to find out, as an outsider, how much progress will be made before the June European Council, which will still be under the Czech presidency. And you may have read reports in yesterday's Irish Times that there's some suggestions that it might be delayed a little longer. I would certainly be interested to hear, we all would, on Views on the Floor, as to what is happening to actually give concrete effect to this commitment by the European Council in December. The first substantive area I'd like to refer to, and quite briefly, is cheap labour. We've had, in 2005 and 2006, it seems a long time ago now, very well-documented, well-publicised race to the bottom concerns. We had the Gamma case, we had the Irish Ferries case, and we had allegations, in some cases quite well documented, on the exploitation of accession member state workers. Now clearly there is an EU dimension here, but a lot of this has been recognised has to be solved at national level. And there's a lot of work being done on this by both sides of the partnership towards 2016 and the Review and Transition Agreement last year. Everything is moving quite slowly, and one of the concerns I would have is if these issues are going to be put forward as solutions to the social concerns raised in Lisbon I, there has to be concrete belief that the problems are really being addressed by the time we get to Lisbon II. But we have the establishment of NERA, albeit on a provisional basis, and we have the Employment Law Compliance Bill last year, and progress is slowly happening on that. We have the Employment Law Consolidation Bill, which is going to try and bring everything into a more coherent, updated framework. One small negative is that, as a reflection of the times we're in, it was decided to continue the exclusion as regards workers from Bulgaria and Romania, to which I address my personal regret that that happened, but that is a sign of what is happening and stands in stark contrast to what happened when the Poland, Czechoslovakia and the 10 member states came earlier on this decade. Mention of the Services Directive, which would be a seminar all in itself, but certainly there was a recognition, much to the satisfaction of many member states, that host country employment standards would apply to service providers coming from other countries. But I would caution here that the Services Directive is riddled with references to in accordance with community law. It's a Services Directive essentially inspired by the fundamental freedom to provide service provision of the ETUC Treaty. And I can reasonably confidently predict that there will be scores of cases brought before the European Court of Justice where we're going to see potentially the same sorts of problems as we've seen in relation to posting of workers and the right to strike. And then finally, in relation to cheap labour, by the way, is just a general term of art, but it just describes generally the concerns that European social legislation is, in fact, encouraging cheaper labour coming from outside, pitting worker against worker, and resulting in overall a race to the bottom and lower wages and lower standard of living. I mentioned here the directive on temporary agency work, which was a fairly big thing in the Lisbon Treaty campaign. People saying the EU has failed to do this and the UK and Ireland have conspired against a speedy resolution of this issue. The directive was in fact accepted by the Member States much at the same time as the referendum, and it was adopted in November 2008. And what we're seeing is a long drawn-out process on how that directive will be made to apply in Ireland in due course, with a implementation date of 5th December 2011. This is how it's so sensitive. Posted workers. We're talking about a 1996 directive of posting workers in the framework and provision of services. It's based on the EC Treaty services provisions, and it involves a coordination of member state laws to lay down a nucleus of mandatory rules for minimum protection to be observed in the host country. The expectation of many of the member states and economic actors involved was that we would see a situation where deference would be paid to national systems of employee protection, and that they would apply in a very broad way to workers who were coming into that member state under the directive. But the Commission certainly adopted a fairly strict approach, and a number of cases have come before the Court of Justice, starting with the Laval case, which show that the Court gives a primacy to the provision of services from outside. It applies the provisions of the directive rigorously. So if member states have not taken great care to fall within the permissions, if you like, granted to them by the directive, then they can't avail of it. And essentially, Laval posted Latvian workers to Sweden, and there was collective action to force it to sign a collective agreement in Sweden. The directive only applies in relation to minimum rates of pay if there are national measures regulating this issue, or there is, in simple terms, a qualifying collective agreement. And essentially, Sweden did not have such national measures, and there was no qualifying collective agreement. I'm sorry, I'm going through quite quickly because I think you're going to cut me off in about 2 minutes or so. But
poised.
Have I got 2 or 3 minutes to?
Yeah, 3.
3 minutes.
Unless you're not banging bottles on glasses, and you know what that means.
Then we had the Rufford case of April 2008, where essentially the rule applied to public contracts. And there was a requirement for the overseas service provider to submit to local terms only in respect of public contracts. And the Court of Justice said you really must apply this across the board universally to private and public contracts. And because you do not do this, then the local rule cannot apply. And then in the you said it's very sensitive, indeed. In the Luxembourg case, we see a member state which is hauled over the coals for its incorrect implementation of the posted directive. It gave too broad a definition to the concept of public policy. Its requirements in relation to monitoring were unclear and ambiguous, and its requirement that there had to be a Luxembourg resident expert to obtain the documents for monitoring purposes was not necessary to the effective carrying out of the monitoring work. So the way forward argued that the Court and the Commission has subverted the intention of the legislator. This is part of the course with directives, that you have the member states agree a directive together with the Parliament, and when the Court of Justice comes in, it's not what the member state said at all, and there's an obvious argument that the Court of Justice has subverted the intention of the lawmaker. The Court has rigorously interpreted the directive. It's given priority to the freedom to provide services over national social policies. Little respect seems to be paid to the choices made by a member state. So there are now proposals to revisit and to change the directive to rebalance the position in favour of the member state and calling for changes in the European Commission approach. And generally, we have the Social Progress Protocol proposed by the ETUC to rebalance the relationship between fundamental rights and economic freedoms. We see a similar problem in relation to the right to strike of the Court of Justice. And all I would really say here is that the Court has followed a well-known classical approach under which free movement rules trump national measures in areas of national competence. And the Court placed severe limits on the ability of member states to override free movement rules on the grounds of the fundamental right to strike. And we saw that in the Viking and the Bow case.
And your last point is?
You're being very cruel. Can I just speak to the last two slides?
Quickly.
The right to strike the way forward. The Court of Justice has paid lip service to the fundamental right of collective action, effectively subordinating it to internal market freedoms. We're going to be talking about the ETUC proposal. I won't spend more time on that. And the question to me, will the issue be addressed in the June European Council? As I said, it's the economy stupid, as much as Lisbon. My view would be that the Treaty of Functioning of the European Union, including the Charter of Fundamental Rights, sets out a viable framework for articulating and developing workers' rights. A restrictive interpretation by the Court of Justice is difficult to check in the absence of what I describe as constitutional change. Member states have a critical role in participating in decision-making, especially in legislation. And they need to be careful how they do this. If you look at the Services Directive and other similar measures, they have a critical role in robust and timely implementation, which becomes urgent when you get to Lisbon II, and in defining the correct balance between social and economic rights. But above all, beware blaming the European Union for essentially national policy and implementation failures. I'm sorry, I wish I'd been given another 10 minutes, but I haven't, so that's it. Thank you.